Hello and welcome to the October update from the dispute resolution team at Herrington Carmichael. My name is Robert Sims, I'm a dispute resolution partner here. This month I want to talk about the new pre-action protocol which came into force on the 1st of October and applies to any business, including sole traders and public bodies, that are claiming payment of a debt from an individual. That individual might also include sole traders. There is a link to the protocol on the file attached to this video, which you can have a look at. The pre-action protocols are designed to encourage early engagement and communication between parties that might be involved in a dispute, with a view to try and resolve matters without the need to go to court. The protocol requires those that are owed money, so the creditor, to send an initial letter of claim, and with that letter of claim there's certain information that should also be sent. There's details regarding the amount of the debt, whether interest is applied, and how payment can be made. There's also paperwork to be sent with a letter of claim, including an information sheet and a reply form, and there's also a financial statement which can be completed by debtors as well. The party owing the money, the debtor, is to be given 30 days to respond, and that's a significant change from earlier protocols in relation to debt claims, as the debtor was only ever given 14 days. So there's an increased time frame there to cope with. Any response to the debtor should be made using the reply form, and there should be, if there's any request for paperwork, whether legal advice is being sought and whether time is needed to settle the debt, then additional time should be given to the debtor. If the reply form is returned partially completed, then the creditor should accept this, that there has been a sign that the debtor wishes to engage with the matter and make a reasonable attempt to discuss the debt and reach a settlement if possible. If settlement is not reached, the parties are encouraged to consider alternative dispute resolution, so things like mediation, before court proceedings are issued. If a resolution is reached, so if there's a payment arrangement but the debtor then fails to adhere to it, the creditor has to go all the way back to sending a letter of claim before any court proceedings are issued. The courts are going to take into account non-compliance with the protocol when they are giving directions for the management of a case which goes into court. Minor or technical infringements will most probably be overlooked, but the court will want to see compliance in substance. If there has been a failure to comply, the court can impose sanctions, including a stay of the proceedings to allow time to comply, or ordering a party at fault to pay costs. Interestingly, there are no sanctions imposed upon debtors who continue to raise redundant or dead issues, and the sanctions regime is very much one-sided in favour of the debtor at the moment. The pre-action protocol is clearly designed to prevent businesses issuing debt claims without attempting to resolve the matter first, and that's a sensible thing. With the current cutbacks and closure of many courts around the country, that comes as no surprise. But debtors and businesses are going to be forced to wait longer before their debts are settled if they're relying upon the court process, and I don't see that as being a positive step. I'd hope that steps also will be taken to adjust the protocol, or at least impose more effective sanctions upon debtors who play the system by causing delay or entering into a series of payment arrangements that fail because clearly they have no intention of resolving the issue. One has to question whether the protocol was necessary in the first place, as the statistics from the court service show that in the final quarter of 2016, over 90% of cases proceeded to a judgment in default, so that's without a hearing, or were actually admitted by the debtor without need for any further action by the court. Deterring court users from issuing court proceedings is likely to reduce court service revenue, and that may mean in 2018 that will be bad news, with further increases in court fees to try and offset that reduction. One thing to note is that insolvency proceedings are not caught by the protocol, and creditors with an undisputed debt may now wish to consider use of a statutory demand as a route to recovery when otherwise they might not have done. As I said, there's information on the protocol attached to the links associated with this video, but if you would like further information on this or any other dispute resolution topic, then please do contact us on drteam@herrington-carmichael.com. Thank you.